I rise this afternoon to speak on the Telecommunications Interception and Access Amendment or Data Retention Bill 2014. Mr Deputy President, I feel as if the parliament is playing catch-up and not doing it terribly well with what is in fact a revolution going on. And the revolution, or the major transformation, is in big data. And we've now got to the point where the revolution is not in the machines that calculate the data, which has been something which has been our lived experience and which Senator Kate Lundy just spoke about in her remarks leaving the parliament, the transformation in terms of the machines and the technology that actually calculated the data. But now the revolution is in the data itself. And I am strongly opposing this legislation because I think the overwhelming majority of people in the parliament have got no idea about what the retention of data actually means for the Australian community, for society in general, or what it could mean in the longer term. We have got to a situation where we have always had an understanding that because we could only deal up until now with relatively small data sets, we have always looked for evidence, analysis and causation. Looked at the data set, looked at the evidence, tried to work out the causes, tried to extrapolate that to evidence-based decision-making. So causation was actually where our focus was. Now the whole world is going to be shifting to exchange causality for correlations. So in other words, no longer actually needing to know why, just focusing on what. So you get the correlation in the data, and that gives you the information. Where do people go? What do they eat? Who do they see? Which doctor are they going to? What does the information mean? Nothing about causation, nothing about evidence, just about the correlation. And it's got to the point where that data, the more that you know about people, where they go, what they do, what their health is, the more you know about that, the more correlation, the more valuable that data is to various businesses. And the problem we've got, essentially, if you collect data on people, the primary purpose for which data is collected, you don't know even now as we stand here how in 2 years' time that data might be used for something entirely different. The data itself is now the product that is valuable to corporations, to governments, to anyone who gets hold of it, to actually make decisions, to actually be able to sell products, develop products. And we've got to the point where, and an example here of mobile operators, for example, I'm quoting from a book, Big Data, but mobile operators have long been loath to monetise that information for fear of running afoul of privacy regulations. But they're starting to soften their stance as their financial fortunes flounder and they regard their data as a potential source of income. In 2012, the large Spanish and international operator Telefonica went so far as to create a separate company called Telefonica Digital Insights to sell anonymous and aggregated subscriber location data to retailers and others. So there is the new market for people who've got the data to on-sell it to other people for profit and to basically use that data about people. Now the argument will be, but yes, you can make it anonymous. Well, you can't. What is clear is even if you try to make it anonymous, you can't, because the data set will match somebody, and inevitably that person will be locatable. And that's one of the big problems that we have got. So where we've got to here is a parliament which is deciding to legislate to allow the data about every Australian to be kept by telecommunications companies to store that data for 2 years. That data is incredibly invasive. It's going to tell you everything about that person, where they've been, the fact that they used their phone and who they spoke to, for how long they spoke, and then the network of people that those people spoke to, and you're going to build up a whole set of data about that person. And who's going to have access to that data? Well, Mr Deputy President, there is no saying in this legislation that that data is going to be held by these corporations in Australia, controlled in Australia under Australian privacy law. What is to stop one of these providers who will store this information for 2 years actually storing it in another country where the privacy laws, where the data storage, where the privacy laws are not going to be the same as Australia's, and they do, like Telefonica has done, actually allow access to that data for medical insurance companies, for example, who might decide that they wanted to determine whether they should give someone health insurance or the cost of that health insurance over time. And there's an extraordinary example that I've read about where a car company, for example, is designing the most right up-to-date seats, so that when you buy the car or get the car, you can log in the impression of your body as you sit in the seat upright in that car. It will then program the car so that if you slump over the wheel or if you actually start going to sleep, the car will wake you up. And so it's meant to be a safety device, except that that data is then owned by the company, which can then make that data available to law enforcement agencies in the case of an accident, or insurance companies in the case of an accident, to say that you went to sleep at the wheel of that car, or that you were distracted, leaning across, whatever you were doing, because of the physical imprint in the seat of you sitting up. If you are not, then that can be made available, and you find yourself suddenly, the data will get you in the end. You are actually getting to the point where you are going to make yourself vulnerable to the data collection agency that holds that data, and whether they on-sell it or make it available or are vulnerable to having it hacked. And yet this parliament is saying 23 million Australian people are going to have all their data stored somewhere, and the government and Labor think that that is perfectly all right to actually do that. Now, we've already had a situation where you had up to 80 agencies already being able to access people's data. That is going to be pared down in this legislation, but the big flaw in this is that all those agencies have to do is apply to the Attorney-General, and he can, or she can, then allow those new agencies to be on the list of agencies that can collect the data. So we've got no idea what the Attorney-General of the day will rubber stamp in terms of saying any of these agencies can have access to the data. Now, of course, we know that ASIO, we know that the police, we know all of the law enforcement agencies will want this, but it's being dressed up as terrorism, to deal with terrorism. Nothing could be further from the truth. This is something that these agencies and many government agencies, as I said, up to 80 agencies now, want this data because it makes it easier to either track down information about people or engage in audits of compliance, enforcement and the like. Now, what we now have with this is a real situation of considerable concern that these agencies actually wanted 5 years, but they're not going to get it. They're getting 2, but that is in fact too many. We are seeing a real concern here about what is going to happen to information that pertains to all Australians. And what about confidentiality, as I said? Now, the Labor Party seems to think that because it has arranged some very thin confidentiality arrangements, might I say, to protect journalists and their sources, and I'll come back to that, it actually doesn't protect their sources. But what about doctors? What about lawyers' groups? What about any of those organisations which actually require and demand privacy of information? They will no longer be able to have that, because the only group of people protected through this, fairly thin new public interest advocate, but what about the people who actually provide the information? What about doctors? What about lawyers? They are not covered. So, in fact, any information about any individual can be uploaded, held for 2 years, no confidentiality provisions. It actually undermines everything we've understood about the rule of law, about professions that are protected with the information that they actually hold. Now, what we are also getting is the idea that, as I said, causality has gone. We are now having correlation, and correlation allows people to work out probability. And so we are going to get profiling of people and communities as being likely suspects in particular crimes. This group of people have a greater probability, according to the data, of actually committing a crime. It doesn't allow for individuals in that community for any analysis of other things in that community, and so you're going to get additional policing put in those areas, you're going to get additional surveillance in those areas, and it's completely unnecessary. Now, we're not saying, and this is where I heard a few comments earlier that the Greens don't want to see adequate surveillance from police and organisations, our law enforcement organisations dealing with terrorism. Well, of course we do, and that's why there are data preservation orders. If they have reason to suspect that somebody is likely to be involved in criminal matters, then they can get a data preservation order. So targeted is one thing. Indiscriminate surveillance of an entire population under the guise of terrorism and national security is quite wrong. This has been on the agenda for a long time. Under the shadow of terrorism, we have had Labor roll over, go and join up with the government and agree to legislation that will lead to surveillance of all Australians. Now, I just want to go to this public interest advocate that has been set up to oversee the metadata searches on journalists. Well, there are a number of problems with that because there are no rules requiring the Attorney-General to seek the views of the various of the public interest advocate to argue against warrants being issued for journalists' metadata, and in addition it will be an offence involving 2 years jail for anyone to disclose that a warrant for metadata has been requested or applied. So the journalist won't be able to actually contest the idea that this has actually occurred. Testimony from the Attorney-General's Department, combined with evidence from countries which have enacted data retention, has shown that there is no evidence of improved crime resolution statistics once data retention is enacted. Law enforcement agencies have consistently claimed the extra powers are needed, but they have failed to provide any concrete examples of why it's needed. And in fact, it's to the contrary. I was surprised to see that the Attorney-General was going on about how this is the way that Western nations are going. No, it is not. Western nations are actually going in the opposite direction. That's why I said in my opening remark that this parliament is playing catch-up. Well, the fact of the matter is the European Union had a directive on this in 2006, a data retention directive. In 2006, John Howard was Australia's Prime Minister. I don't think he would have even had any idea what data was doing at that particular time in terms of retention, in terms of the transformation, what it would do. 2006, and since then, countries have been winding it back because in fact the European Court of Justice found it's unconstitutional. Austria has used it for theft, for drugs, for stalking, but not for terrorism. Poland has used the data mostly for civil disputes and to assist in divorce cases. In Denmark, it was given up in June this year, and Germany abandoned the legislation in 2010. So it's not about national security. It is about collecting data on every Australian for every law enforcement agency and regulatory compliance agency to use. You'll get this data this surveillance capacity and data being used for everything from crime to trivial infractions of various things, from the tax office, the ACCC, ASIC, from fisheries, for health compliance agencies, for local government and even the RSPCA. There are any number of organisations which have accessed data for various reasons. Now, that is where we will actually end up in this country, where once you are identified, once your data is there, it will be used, and we can't even know now what the secondary use of that data will be either next week, next year or in 2 years' time, how you might be able to use that data or what it's actually for. Then we go to the cost of it. I mean, this is an extraordinary thing, that we've got the Labor Party agreeing with the Abbott government that we go ahead and conduct the collection of data on every Australian for 2 years, and we have no idea what it's going to cost and no evidence that it actually assists in doing anything about terrorism. This is an extraordinary lie that's being perpetrated on the Australian people. Now let's go to cost for a moment. We have no idea what it is going to cost. The companies and government agencies will not only need to store the data, but they have to ensure it's stored safely. And as I said before, how do we know that it's even going to end up being stored here? Now, it will be very attractive for the reasons I indicated earlier to hackers, and I want to know how the government is going to guarantee, if the data is not stored in Australia, how it will meet Australian privacy laws or will be protected from hacking. But let's go to the actual cost. What is it likely to cost a year? We've got all this talk. We had a budget emergency. Now we don't have a budget emergency. Last year's budget was to fix the emergencies. This year's budget's going to be dull. It's very interesting the way that the news about the budget travels. But what is the cost? Australians deserve to know how much the government intends to contribute to the mass surveillance of the Australian population. How much money are we going to put up to have this surveillance on ourselves? Surely the parliament deserves to get an answer to that question. Well, we don't have an answer to that question, and it is fundamentally wrong. When we get to this idea that if you're not doing anything wrong, you have nothing to hide. Well, that's what the Stasi said in East Germany as well, and it's what every police state has to say. We will follow you, we will do surveillance on you, but don't worry about it. If you have nothing to hide, it won't be a problem for you. Well, we saw what happened with the Stasi in East Germany, and we know about the chilling effect that this will have on people. It will mean, for example, that you will know who attends a protest rally, for example, anywhere. You will have their location. If they make a call or have their phone on them while they are there, they will attend that rally. Now, what is that worth to a foreign government, to know who's been there and which of their overseas students was at a rally against human rights, for human rights abuses, for example? Who knows how anyone is going to use this data on particular individuals? So this idea, if you're not doing anything wrong, you've nothing to hide, is no excuse whatsoever for this invasion of people's privacy. And when you get to the issue of trusting our government bureaucracies and intelligence agencies, what about the scrutiny? What about the oversight that we need? Because you know that if there's not proper oversight, you will have corruption, you will have creep in what this data will be used for. Today, people are deciding which agencies can access it, but as I indicated, the Attorney-General can change that any time, add new agencies, add different levels of surveillance, and that's where we will end up on this. When we get to looking at this as an overall objective in Australia, I think it's really sad that we've got to the point that we are legislating without evidence.
Order, Senator. Your time has expired.